Saturday to educate us and also answer a lot of our questions on immigrations. So, Lawyer Eunice, welcome to Hanging Out with Vicky on the Legal Hour.
Hello, Vicky. How are you?
I thank you. And you?
I'm doing well by God's grace. And this is the last Saturday of the month, isn't it? Hope the month has been good for you.
Yes, it has. It has been. It has been. Before Lawyer Eunice even introduces herself, even though I've done the introduction, I also like to ask each and everyone who is watching, if you have any questions or queries you want to contribute to the program, do not hesitate. Send us your questions, queries, and comments on all our social media handles at Heritage TV. So, Lawyer Eunice, over to you. If I may ask, why this specific topic? It's a very unique one because when you made mention this is what you wanted us to discuss today, I was just asking myself, I never, step
Yeah.
parent leave to remain. This is something I've just heard because I thought usually it's rather the biological parents who can apply for leave to remain, especially if you have children. So when
Yeah.
you made the step parent, I was like, oh my goodness, this is also another one. I'm really intrigued,
Yes.
and I,
And so this is one of the areas that most people don't know about or are not aware about. Like you said, if the biological parent is making an application, then of course, then they will be able to depend on whether it's the spouse or the child to then make an application. But this is such a niche area, and obviously, because most people don't know about it or are not aware of it, especially when it comes to couples who may not have a child together with the British partner or the settled partner, they're thinking, so what else? What else do I do if we're married and we don't have a child together? Then what do I do? Doesn't mean that I have to return, or doesn't mean that I can make the application from here. And so if you don't have a child together as a spouse, or you've been living together as partners and you're thinking, what next, or what is the other option for me, then obviously if there's a child um, on the side of the person who is settled or who is British, and that child is under the age of 18, then of course you can also rely on that child when you're making the application. So it's good to make people aware of this area of law so that at least they are aware, because when you come to our immigration rules as well, uh, somebody with parental responsibility is not just a biological parent. It can be an adoptive parent. It can be a guardian. It can be somebody who has been given a court order to take parental responsibility for the child. It can also be a step parent as well, or a relative who has been given such an order by the court. So it's not just limited to the biological parent, as we all know. The immigration rules, in its definition, makes, provision for all these types of people who may be given parental responsibility over a child.
so as you were mentioning, grandparents, other relatives, can a neighbor, you have somebody who would want the neighbor to take over looking after the children, who would be in charge of the children? Can a neighbor also seen as a step parent in this situation? That is when they've signed a document saying
Yes.
that they.
Okay, so yeah. So if it's a neighbor, then definitely there should be a court order giving that responsibility to the neighbor. So it's not just you saying, "Oh, my neighbor takes care of the child, and so she has some responsibility over the child." I mean, most parents would take their children to childminders and to nurseries, but we wouldn't say those people have parental responsibility over the children. So if there isn't any court order granting that neighbor parental responsibility, you can't just automatically say because they take care of the child, therefore they have parental responsibility. And just as well as a sister or a brother, if you're saying your sister or your brother takes care of your children, that doesn't necessarily mean that they have parental responsibility over your children. It is just because they're helping you out. So you can't then say that because your sister or your brother helps to care for your children, therefore they have parental responsibility. There has to be some sort of court order which gives them that right to be able to say that they have parental responsibility because maybe the parent of the child has abandoned the child, or the parent of the child is not capable of taking care of this child, or the parent of the child has passed away. So there must be a reason why the court will grant such an order. So it's not just by word of mouth. You have to have an order which goes with it. Whereas a step parent has is somebody that has come into the family, and so where the other parent is no longer in the picture. So that other parent may have abandoned his role, and now this other parent has taken over that role per se. And that is why that parent is now a step parent. And so that is totally different to a relative who helps or supports you with childcare, which I'm so grateful to have. I have a good family that helps me with childcare, but none of them, apart from myself and my husband, have parental responsibility for our children.
Started coming in. We just have those who are watching us on Facebook, YouTube, social media. I can't mention everyone's name. Please pardon me, forgive me with all your names, or else we're not able to finish, what we came to do. So I also want to say hi to Adam. Thank you for supporting us, joining us, and I also say thank you to CEO Michael. Thank you so much. I also say a big hi to lawyer Richard of Legal Life Solicitors. He's also a part of Legal Life Solicitors. I've seen him on social media, with us, and also to Mr. Benedict as well for the support. He's watching us as well. My goodness, the first question I have here is this person has been married to his wife for the past 3 years, and she has three kids in this relationship at 10, 8, and 6 years old. We do not, they do not have a child together, and we want to find out if it will be possible to make an application based on.
Okay. So first of all, if we look at our immigration rules, if you look at Appendix FM, which is the appendix for family members who want to make an application based on our immigration rules, the main sections are to do with parents and to do with children, or should I say, uh, children, parents, and then partner. So those are the main areas. They are not the only areas, but those are the main areas when it comes to our Appendix FM. So you have the parent route, you have the child route, you have the partner route. And today, obviously, we are directing our topics towards step parents. And in this person's question, they are asking, well, I've been married to this partner for this number of years. Do I still have that capability, or am I eligible to make this application based on the fact that I'm married to this woman and then she has children of her own? And we don't have a child together. So is it possible that I can make the application? Of course. So if you look at our partner route, so where you are eligible to make an application as a partner under our immigration rules, you wouldn't be allowed to make an application as a parent. So if you're eligible for one route, you stick to that one route. They say if you're even eligible slightly for the other route, they will first consider the partner route even before they look at whether you have any eligibility requirements met under the parent route. So he's a partner because under our immigration rules, Gen 1.2 says that a partner who is lived together with that other partner for a period of 2 years can be considered a partner. Or even if they haven't lived together for 2 years and they are married, so they are husband or wife, then that person is a partner. Or somebody who is a fiance or fiancée is a partner, or even somebody who is a civil partner, which is not of a heterosexual nature, but also of a homosexual nature. Those people are also considered to be partners. So they have a broad definition of who a partner is under Gen 1.2. And if you look at this question, considering that the man has been married to this lady for the past 3 years, he meets that definition under our Gen 1.2 of the immigration rules. And so, therefore, when you look at the partner route, there are certain eligibility requirements that he also has to meet. So, now that he's a partner, does he meet the relationship requirements? So, number one, the relationship requirement is their relationship one, which is genuine and subsisting. So is that relationship they are talking about, their marriage, can it be seen to be a marriage that is genuine? They say they've been together for 3 years, which is fantastic. Is it continuing? Can they provide evidence that they are living together, for instance? Can they provide proof of address that over that past 3 years they've continued to live together as a family unit? Fantastic. Then at least you know that the relationship is genuine and subsistent. And of course, they have to be over the age of 18. So that's another thing that they need to also be able to meet. As long as they are over the age of 18, then obviously they are not within a prohibited degree of relationship. And they also have to be able to show that if they were ever married before, that they've been divorced. So they are not in, should I say, a polygamous relationship. So as much as possible, in the UK, such relationships are not regarded. And so if they've been married before, they have to definitely show that they've divorced and they are now in a new marriage or in a new relationship if they are to rely on this partner route to make an application. And they also have to be able to show that they have every intention of living together as a couple. And one way of also showing that is the evidence that shows that you've been living together. So if you've been living together and obviously you can show that you have lived together for that period of time, then the intention is that you intend to live together permanently as a couple in the UK. Fantastic. That's your number one requirement met. Then number two, it says obviously you have to meet our immigration status requirement. And if this person who wants to make the application has no leave, no status whatsoever, then that means that obviously he's in breach of the immigration rules, because if you have breached any immigration conditions whatsoever, by being an overstayer or by entering the UK illegally, then you wouldn't be able to meet the immigration status requirement. And when you are not able to meet a requirement, there's something called exceptions. So there are certain exceptions to meeting the eligibility requirements. And 1A, or should I say EX1A of our immigration rules says that if there is a child who is either British or settled or has lived here continuously for a 7-year period, and that child, it can be said that it would be unreasonable for that child to return to the country where the applicant is from, then of course that has to be considered. And usually the Home Office caseworker will have to consider that child who is British or settled or has lived here continuously for a 7-year period, and they will have to look at the child's best interest. So they'll be considering certain factors such as the child's home, the child's what they consider to be, should I say, emotional factors, where the child regards to be their home, their family life, their education. There are so many other factors that come under the child's best interest, and these are factors that the caseworker will need to consider when making a decision on such an application. So if the children who are 10 and I think 8 and the third child, obviously if they are British and they're considering what their best interests are, then they'll be looking at the fact that obviously they are the children of this mother who is also settled or British in the UK. And obviously, they'll be looking at the fact that maybe they've only known the UK as their home, they are really established within their schools. The fact that maybe they have other family members and other relatives living here in the UK, and also the fact that this step parent plays a role in their lives. And so, if this step parent is playing a role in their lives because those children are normally living under his or her roof, then it means that they will be considering the fact that this step parent maybe takes them to school, maybe takes them out, maybe also takes them to GP appointments and the rest. And the way you can evidence this is by way of a school letter. So the school should explain if they know you to come and pick the children up and to also bring them to school. Probably you also go for parents' evenings, or if there's any situation, they have you on their database as an emergency contact and they are able to phone you and also find out more information, or to tell you things about the child if they need any further information. So these are ways or means by which step parent can evidence that they play that role in the child's life. And that role is essential because maybe the other parent who is supposed to be playing that role may not be in the child's life, or maybe because the child is normally living with you, the step parent, and not their biological parent, you have assumed that role and that child has bonded with you. That bond obviously cannot be severed, and because of the fact that you have bonded together as a family, you are expecting that the caseworker will look at the evidence that has been brought forward and will look at the child's best interest to see that because you have formed that relationship with the child, therefore you are eligible to apply based on the fact that you meet the exception under EX1A. And so, in so doing, they will consider all of these other factors and then obviously look at the fact that this parent is playing a role in the child's life. And so, if there are any other requirements, such as the financial requirement or the English language requirement, that cannot be met, the caseworker is still going to be looking at the exception to the eligibility requirement, which is EX1A, to say that, oh, okay, you don't meet these eligibility requirements like the immigration status requirement or like the financial requirement, or you don't meet the English language requirements. Either one of them, if you don't meet it and you are able to show that you meet the exception one or EX1 requirement, then of course they will be able to assess your eligibility based on that. And that is the one that most people are not aware of, that if I'm a step parent and my partner has a child who is under the age of 18, therefore that means that I can also rely on that child or those children to also make an application and have my leave to remain in the UK. So yes, in this case, that person will be able to make an application based on his partner and the children, and he will be granted leave to remain as a partner.
And so, parent, if they adapt isn't part of the child's life, then
Mm,
mom is a partner. They live together for 2 years, as you just stated. There's evidence that they've been together for 2 years. Then that person can apply as a step parent. Now, all of a sudden, the biological dad just shows his face and also wants to take place on his child. How do we solve this issue? Biological father was absent, and a step
Mm,
parent who involved in the child's day-to-day life.
mm. Okay,
Who
so in
advantage, who will be considered in this case when biological father wants to make an application based on that biological child, or the step parent who is also making an application based on the stepchild.
Okay, so in the case where, for instance, the stepfather or the stepmother has been able to apply on the basis that they have a relationship with the partner, and because the partner is taking care of these children, he also has parental responsibility for these children. And when the biological father shows up, it's not just him showing up, he also has to be able to show that he also plays some role in the child's life. So you can't just say that because you are the father of the child, you should be granted leave to remain. You have to evidence it. And when you look at our parent route, so if, for instance, the parent is not living together with the children's mother, and you are looking at the fact that there's the parent route has also their eligibility requirements that have to be met. And one of the eligibility requirements is maybe that they are able to show that they have direct access. So they may not have the sole responsibility for the child, but they have to be able to show that they have direct access to this child. And usually, in evidencing this, the Home Office guidance or the policy states that you either have a court order which shows that indeed you have some parental responsibility, you have direct access to this child, or if there isn't any court order or document to evidence this, it has to be direct, not indirect. So it has to be you are able to see the child, you're able to have contact, you are able to have a face-to-face relationship with this child. If there's no court order of that nature or of that kind, then you should have a letter or some sort of agreement with the other parent of the child to say that you are able to have that direct contact with the child. So you have to be able to show that this parent who is now, should I say, no longer in a relationship with you, can also evidence that they too are in agreement that you have contact with this child. Maybe you come and visit, or maybe you are telling the case home office caseworker that you come and see the children. And so, if you have evidence of the fact that this parent is able to give you supporting letter to evidence that you have some role that you play in the child's life, that's one of the evidence that you will be standing on to say that you have direct access to those children. And then you also need something from an official source. So it has to be either a school letter or a GP letter, which confirms that you have that parental relationship with the child. So if the school can write a letter or the GP can write a letter to evidence this, then of course you can also make the application. But if there isn't any such evidence, then unfortunately, the biological parent who has now come into the picture may not be able to make the application. So yes, if they are the biological parent and they meet all these other requirements, then of course they can make the application based on that child because they have direct access and not just the fact that they are living with the child, but the fact that they have direct access is also one of the eligibility requirements under our parent route when you look at our immigration rules.
The next question is a question which has just was just asked. What if the person is not married and lives with a partner and the children for just over a year? Can he still apply for leave to remain? I don't know whether this means it's over a year. Is it still saying maybe 2 years or more, or just a year? That's the question I want to ask. That the person who
Ah,
right
yeah.
here.
Yes. So I think at the beginning I was saying that a partner under our immigration rules, when you look at Gen 1.2, it states that you are considered to be a partner if you are married, so either that you are the spouse or you are able to show that at least you are the fiance or fiancée of that person who is British or settled, or you're able to show that you are living together with that person for a period of 2 years. And it's specific. You have to be able to evidence that you've been living together for a period of 2 years. Unfortunately, if you are not able to show that you've been living together for a period of 2 years, the application is likely to be refused unless there are certain exceptional circumstances, which means that they will have to consider um, the fact that you are living together with this person. So if you can't evidence 2 years of living together and you are not married, so it's one or the other. You either show that you've been living together for 2 years, or if you've lived together for less than 2 years, show that you are married. Or you have to be able to show that you're a fiance or fiancée who is going to get married to that British person or person who is settled here in the UK. So you have to be able to evidence this. And most times, if you're a fiance or fiancé, you will be able to evidence that you've obviously gone to the registry to make notes of the fact that you want to get married, and they will be giving you a date of marriage and the rest of it. So you have to be able to show this by way of evidence. It's not just by word of mouth. If you've lived together for the 2 year period, you have to be able to show proof of address for that 2 year period. If you say you are married, you have to be able to show a certified or give evidence that your marriage certificate is from a competent authority. So you have to be able to evidence whatever you are telling the Home Office caseworker to look at. So if they've lived together for less than 2 years and like I was saying, they are married, then of course they can go ahead and make the application. If they are not married and they are fiance or fiancé, then they have to be able to show that they have gone to their local council to have a date set for their marriage, and they'll be getting married soon, and they are making the application on that basis. So you should be able to evidence these things if that's what you are telling the caseworker. Otherwise, if you're not able to show this, the application is likely to be refused. And Home Office, they don't joke when they talk about not meeting certain requirements. In showing that there are certain exceptional circumstances, it might mean that you are going above and beyond just the fact that you are a partner, but you are probably saying that there might be maybe certain health or medical reasons, and that's why you are also making these what do you call it, applications based on the fact that you are a partner to the person who is British or settled in the UK.
This is how did to be partner with the and it's a legal something we do a legal education, then you have the need of yourself more so this and want to necessarily your competence to rely on Facebook, rely on you and also you love this this program is sponsored by WF Solicitors, Victim States and Heritage Legal Rights International School. Where yes, I've got another question. It says my husband is sex worker in the UK and has previous relationship. His firstborn son who is 7 years and sometimes during the weekdays. Would I still be able to
Okay. So in a case like this, similar to what we've been looking at, but in this case, obviously, the other parent, who is the biological parent of this child, also has a role they play in the child's life. So, what does the immigration rules say? So, for instance, if this person who is now living with her British or settled partner is saying that, do you know what? I know you have children who are under the age of 18, and in this case, this child is 6 years old. How then can I make the application? So if you look at the partner route, of course, she will meet the eligibility requirements if she's able to show she's lived together with this person for a period of 2 years. As long as she's able to show that she meets the relationship requirements, that's fine. When it comes to the other requirements, such as the immigration and the financial and the English language requirement, which may be requirements that she may not be able to meet, that is when you have to look at the exception. So EX1. If you're looking at exception 1A of our immigration rules, like I said, if the child who is under 18, who is either British or settled or has lived here continuously for a 7 year period, you're saying to the caseworker, you need to consider that this child has lived here or is British or is settled. So, having lived here for a continuous period of 7 years, it will be unreasonable for this child to return to the country that I'm from. And if they are, the caseworker is playing that role of looking at that application and assessing the child's best interest, then they will be also looking at the fact that this step parent may be playing a role in this child's life. And usually, if the child is normally living with the parent who is either British or settled here in the UK, then of course, um, whoever the step parent is can rely on the fact that because that child normally lives with the parent who is settled here in the UK, they can also make sure that they are playing a role in that child's life. So let's say maybe they live with their parent 4 days a week, and then they go to the other biological parents maybe 3 days a week. So they have evidence from maybe the school to show that maybe they bring the child to school 4 days a week, and maybe they pick up that child whenever they can. And that evidence is crucial because it's an official source. So that is something that cannot be tainted by any third party. So they take those official source letters into consideration and they hold them to high esteem. And they will probably say to you they want evidence to show that you are living together with the child. So maybe there are GP letters that go through the house for the child, or the child obviously goes to school, and so the school letters may be sent through the house, or even emails. So maybe the emails will be able to show that this is the address they know for the child. So there might be evidences that will show that, of course, this child does live at this address, and you, who is the step parent, also plays some role in the child's life. So even though the biological parent may have a relationship with this child, because the child normally lives with that parent who is either British or settled, then you are making the application on the basis that, yes, I am a partner to this person, but he also has a child who is under the age of 18 and is British, who lives with us normally. And so I play a role in this child's life, and I believe that it will be unreasonable for this child to return to the country where I'm from, especially because he's established life here. We've also bonded together as a family. His other parent also has a role that they play in that child's life, and therefore you are making the application saying well, I also have a role that I also play in this child's life, and therefore I should be granted leave to remain based on the fact that I have a partner who is British and also play a role in this child's life. So they'll grant you further leave to remain on the partner route because you meet exception 1A to the immigration rules. Yeah.
Yes, mind. These applications, can it only be done before the child resides? That's if we are talking about it. Because I'm thinking about a situation where a step parent is outside the country, for instance,
Mm.
so can that from Ghana?
Okay. So in a case like this, so you will have scenarios where, for instance, somebody who has, let's say, previous relationship, 3 or 4 children, and this new partner, she's met, she wants to bring this partner over, and she's thinking, how do I make the application, for instance, if I don't meet all of the requirements, like I was saying. Usually, in cases of entry clearance, there are different rules. If you can't meet certain exceptions, for instance, if you are saying that you want to meet the financial requirement, which a lot of people have an issue with, and you're not able to meet the financial requirement because of A, B, and C, and childcare wouldn't allow you to do so many hours like you want to do, then there is this case which is Lebanon that came sometime around 2018, and it gives the Home Office, should I say, other things to think about when it comes to meeting the financial requirement. So in entry clearance cases, the exception 1 doesn't apply. So we don't have EX1 that applies to entry clearance cases. So because of the fact that EX1 doesn't apply in those entry clearance cases, this case, which is Lebanon, was seen as like a savior to most people's applications who were not able to meet the financial requirement. So, for instance, if they are not getting in any income, which means the 18,600, then they have to meet whether a third party will be able to sign or write an undertaking to say that obviously they will provide for this person's financial maintenance to be met if they were to come into the UK, or an employer will be able to obviously say that they would employ this person who will be coming to live in the UK, and obviously their income is going to be of maybe a higher threshold than maybe the 18,600 and whatnot. In terms of the child who is the stepchild, unfortunately, they will not be able to rely so much on that because they don't have any parental responsibility for that child. So, because they can't evidence um, the responsibility or the role they play in the stepchild's life, they will not be able to rely on that. But as I was saying, if it's like the financial requirement they can't meet, then they have other alternatives to rely on in terms of meeting that financial requirement. Yeah.
Yes, someone who has 5 years residence card and is
Mm.
unable to put that route as a dependent, can the person apply for leave to remain on the 5 years route based on a British partner and person?
Okay. So, like most times, most people will say, "Oh, I've been given leave to remain on the 5 year route, or I've been given leave to remain on the 10 year route." If you are on the 10 year route, and for any reason you want to switch, obviously, we are here to help, and therefore contact us or see us after the program. In terms of this person, usually any grant of residence card or permanent residence would usually be seen under our EA regulations. So our Immigration EA Regulations 2016 would have specified that if somebody meets certain requirements or meets certain regulations under our Regulation 2016, they will be granted residence card or they will be granted permanent residence. Because the EA rules are completely separate from our immigration rules, most times people assume that because they were living here legally, they will be able to basically switch from the EA route to leave to remain route, and it should be fine. Unfortunately, because those are two different routes of law, they would not be able to just switch and then say that they were living here legally based on the fact that they had a residence card. Because if you look at our immigration rules, for instance, leave to remain and leave to enter, and the fact that you may be granted indefinite leave to remain have completely different definitions to somebody who has a residence card. A residence card will usually be granted to somebody, obviously, who is able to meet the regulations, maybe say they're a family member, or say they are a spouse or a child, or let's say they are an extended family member, and so they were granted residence card based on that family relationship. And if they had to show they were dependent, like in this case, they would have to have shown that that EA sponsor was supporting them, or should I say, granting them a place to live, and also supporting them financially to meet their essential needs. And as we all know, EA regulations were based on the fact that these family members had rights. So even by virtue of them not getting the card, if they were able to show that they were being supported, or they were being financed, or they were living under the roof of the EA national, that right was enough to make them reside in the UK. So they didn't necessarily need the card. It was a matter of right. And therefore, as a matter of right, they were able to reside in the UK as long as they were able to show this evidence. And under our immigration rules, that is not applicable. You have to be able to meet the requirements, and the grant of leave has to be given to you before you say you have valid leave to remain in the UK. If you are not granted that leave to remain, then unfortunately, you will be seen as somebody who is an illegal entrant. So if you are switching from the EA regulations to the immigration rules, it is not a continuous progression of your leave, unless you are saying that you are applying under our Appendix EU. And if you are making the application under Appendix EU to say that you are still relying on this EA national, and you are making the application under Appendix EU to say that you are still dependent on them, then of course you'll be granted leave to remain under our immigration rules, which will be a continuous progression of you living here in the UK legally. But if you are saying you no longer meet the dependency requirements under the EA regulations, and therefore you are making an application on a new relationship, then it will not be continuous, because now you are in a new relationship and you are now trying to make an application based on this partner that you have. And therefore, if you're making an application based on the partner and the fact that this partner now has a child, you will be granted leave to remain as a partner, but on the 10-year route. So it will not be a continuous progression of you having had 5 years residence card. You are basically going to be under our immigration rules, which covers different requirements, and therefore you will be put on that 10-year route if you are able to meet the requirements I mentioned. That maybe you're in a relationship with this person, you've maybe lived together for 2 years, or you're married, or you're a fiance who is about to get married, and therefore you play a parental role in this child's life, and EX1A has been met, and therefore you should be granted leave to remain. You will be granted leave to remain based on the fact that you have that parental relationship with this child, and you'll be granted on the 10-year route instead of, let's say, the 5-year route. So, for instance, if you don't meet the English language requirement, or you don't meet the financial requirements, let's say, EX1A will still apply, and therefore, when EX1 applies, that means that automatically you're going to be put on the 10-year route. They will not even consider the 5-year route, because you are not able to meet all of the requirements. So if you're not able to meet all of the requirements and EX1A has to apply, then you are definitely going to be put on the 10-year route instead of the 5-year route.
If it's refused, what's the
Okay, so usually a case like this, if you are not able to show, so for instance, if you are not able to show that you have that parental relationship with this child, the application is likely to be refused. Or if, for instance, you had some criminal records, but you haven't been sentenced. So these are things that they will also look at, and you didn't disclose it. So they are under our suitability requirements. If you didn't disclose it, that's something that they can say we may refuse your application. Something that will make them absolutely refuse your application is the fact that maybe you were sentenced to imprisonment for a period of 12 months or more. Those are things, for instance, that will cause them to refuse. Or, for instance, if you've got a deportation order which says that you've been issued with deportation and you are to leave the country because you're a foreign criminal, that application can be refused on that basis as well. Or if you have a letter that the Secretary of State has sent to you to say that you are excluded from the UK and you cannot be here any longer, those are things that can cause the application to be refused totally. And if, for instance, you have not made any effort, you owe the NHS, you have not made any effort whatsoever to be paying for your NHS fees. So you have a bill and you haven't made any efforts to even start paying those bills in installments, or you haven't come to an agreement, that can also cause them to refuse the application. Or let's say that you've gone through other court cases, especially if it's to do with litigation, and you have court fees to pay, and the court has ordered that you pay certain fees and you have not paid it, that also can cause them to refuse the application. So in cases like this, these instances can cause them to refuse. And if for any reason you are making such an application, first seek advice and then at least let the legal advisor advise you as to what the requirements are and what the suitability requirements are, so that you will be able to make the application knowing that at the back of your mind you have everything intact so that you're not refused. But if for any reason you don't meet certain suitability requirements and your application is refused, at least you know that you will be given a right of appeal. With all human right cases, regardless of whether the relationship was formed as a biological parent or as a step parent, because you are saying that you have that right to family life here in the UK, you will be given that right of appeal because it's a human rights case. And so, if there is a basis for you to appeal, then obviously seek representation, get the right advice as to how you can obviously lodge an appeal, and then how you can make your case more successful based on whatever evidence that you are able to also show as well. So definitely on human right basis, you will be granted rights of appeal based on our Section 82 of our Nationality and Immigration and Asylum Act. And in terms of things that may be refused if we believe that maybe there are certain evidences that were overlooked or could have been looked at properly, of course, then we would say make a re-application. But if not, definitely appeal and seek proper legal representation as to how your appeal can be successful. So yes, with all human rights cases, an appeal can be lodged because they will give you that right to appeal under our Nationality and Immigration and Asylum Act. So yes, if for any reason this is refused, you will be given a right of appeal. Yeah.
We've come to the end of this show. Really, this is giving us the chance to everyone wants to get in touch with her. I come to realize that when this is on the show, people are so much what she's explaining and telling us about the topic that they tend to forget what to have the number. Then whilst I am asleep, you see people ringing me so many messages. Some people assuming that I'm a solicitor. So as soon as I pick up the phone, they start telling me, and my husband was on vacation, and I was. So I feel like I'm so I'm not a solicitor, but I'll direct you to. So I'm saying it on air. Hi, Vicky Newton. I'm not a solicitor. That is why our learned solicitor here from solicitors, Eunice, who comes here every Saturday to tell us, a lot or tell us more about immigration issues. So I'm just clearing the air that I'm not a solicitor, but
Yeah.
when I disagree, I'll let everybody know. At the moment, I don't have a or law. Yes. So thank you so much. Yes.
It's interesting you said that because when I get calls coming through, they'll ask me, "Are you Vicky or are you the solicitor?" And that's one of the first questions that they ask as soon as they call. And I'm like, "Yes, I'm the solicitor. I'm not Vicky. Vicky is the host of the program."
So thank you so much for doing this. So at least I'm not making it up. But you can
No, no,
confirm,
no, no.
please do that. You call me or send me a message. I'll direct you straight to Lawyer Eunice who will handle your issues for you. I'll take this opportunity to also announce that BWF solicitors will be having their Facebook, the community and the law. It's a Facebook program that they do every Saturday, 4 p.m. So they'll be having it today at 4 p.m. And a representative from BWF solicitors, lawyer Francis Owusu Bosompem, will be the guests on the show. And the topic they will be discussing this afternoon is how to sponsor someone to work in the UK. So I will entreat all of you to jump on today at 4 o'clock and listen to what they've got for you. If it's not for yourself, you could even, invite your friends, loved ones, please. You might not know who need this information. So 4 o'clock, go on Facebook, BWF solicitors. They have this community program and the community and the law coming on every Saturday 4 p.m. To discuss issues what we've been doing today. So, Laura Eunice, for the benefit of those who just joined in and just heard you talking today, please tell them how to get to you if they have any queries or questions. And your location, please. Not
Okay.
your home.
So No, of course not. So, as I was discussing with Vicky today, if you're a step parent and you live together with your partner who has children of her own, and the children are under the age of 18, you play a role in the children's lives. You take them to school, you take them to medical appointments, and you're able to get evidence from the parent who is your partner, and also from the school or from the GP, and you're able to also show and establish that you have a relationship with the partner that you are living with, then of course you can make this application based on the fact that you're a step parent and also a partner to this person who is either British or settled here in the UK. If you need further information or you would like us to help you make an application because you find yourself in this category of people, please do not hesitate to contact myself or our BWF team. We are situated in Seven Sisters. The address is the fourth floor of Anna House. So, fourth floor of Anna House, 214 to 218 Tottenham High Road, and it's London. The postcode is N15 4NP. So, N15 4NP. Our office telephone number is 0208 493 7340. So 0208 493 7340. My personal contact out of office hours is 075 35 81 3910. So it's 075 35 81 3910. If you need any other legal questions answered apart from what we discussed today as well, please do contact us. We are also open from Monday to Friday from 9:30 a.m. to 6 p.m. And as we all know, the government has given strict guidelines about those that are able to go to work. So we are keeping to the strict government guidelines. We make sure that our clients wash their hands, they use the hand sanitizer when they come to the reception. We have the face masks for those who don't have face masks on, and we make sure that social distancing is always kept between you and any of our staff and the solicitors. So we are keeping to the strict government guidelines, and if for any reason you feel that you are too vulnerable to make it as well, give us a call and then we will take instructions over the phone as well. So thank you so much, Vicky, and thank you so much for listening and joining us today.
Really appreciate you and adore you as well for always making it to our Saturday show. You've never told us, oh, Vicky, I had a headache, and because of that, I don't think I can make it. You always make it a point to, on every Saturday to us. We thank you so much. You are not taking it for the sacrifices and the time. Thank you so much, Lord Eunice. And take care of yourself,
Thank
and I
you.
hope you send our regards to your family as well. Thank you so much.
I'll
Ladies
tell
and
them.
gentlemen, you can contact her. You know, the details she's given you. She's also given you her office address. Before I, end the show, I would also like to announce that we welcome anybody who would like to sponsor our show. If you also want to come on our show, please do not hesitate. We would like to hear from you. Contact me on 0744-8619-711. And if you'd like to sponsor our show as well, do not hesitate. We would love to hear from you. The number is still the same, 0744-8619-711. So, ladies and gentlemen, we thank you so much. staying with us throughout the show. We wish you all the best. And as Lawyer Eunice also mentioned, let me reiterate, please observe this, the government guidelines. We need you alive. So keep on washing your hands, using your hand sanitizer as well when you're out and about, and always cover your nose and mouth with a face mask. Take good care of yourself. Stay blessed. We love you all. Bye-bye.
BWF Solicitors, we take pride in our clients' service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.